Welcome, deep divers. Get ready for a truly fascinating journey today. We're about to explore the very blueprint of a nation, the constitutional framework of Papua New Guinea. This isn't just about dry legal text. It's really a living document that shapes PNG's identity, protects rights, and structures its entire government. Our sources for this deep dive are excerpts directly from PNG's constitution itself. It's a complex document, quite revealing.
It really is. And our mission really is to peel back those layers, pull out the most maybe surprising facts and the crucial insights. We want you to walk away with a real feel for how Papua New Guinea operates at its core, especially, that unique blend of global legal principles and those, distinctly local adaptations.
Right. So as we uncover these layers, maybe keep this question in mind. How does a relatively young, independent nation manage to balance sort of long-standing traditions with the demands of modern governance? And what clever safeguards has it built in against things like corruption or political instability? Let's dive in. So right from the start, the text says, Papua New Guinea is a sovereign, independent state. Constitutionally speaking, what does that actually mean for a country? Our sources show that even its name, the independent state of Papua New Guinea, and its variants are specifically protected by law. An act of parliament. Its territory covers everything it had before independence, plus internal waters, the territorial sea, what's underneath. Here's a really powerful bit. Its sovereignty over all that territory and its natural resources is absolute.
Yes, subject only to international obligations that PNG has freely accepted. That's a very strong assertion of control. And what's immediately striking is how quickly the Constitution moves to, solidify national identity. It provides for symbols like the flag, emblem, motto, seal, anthem. It signals a very deliberate assertion of nationhood right there in the foundation.
Makes sense.
And it's practical, too. It says, until Parliament makes new symbols, the ones used just before Independence Day remain valid. Continuity, you see.
Right. Continuity while building something new. That makes perfect sense for a new nation. But how do you secure loyalty? From citizens, from leaders, especially in those early days, the source material shows a distinct declaration of loyalty to the state, the people, and the Constitution itself, adopted August 75. But here's the really unexpected part. This declaration exists alongside an oath of allegiance. And that oath is still made to Her Majesty Queen Elizabeth II, her heirs and successors according to law.
It's a fascinating duality, isn't it, this blend? Loyalty to the new state, allegiance to the monarch. It sets a really unique stage for PNG's governmental system.
How so?
Well, it speaks to a very pragmatic decision, perhaps. How do you balance inherited structures like the constitutional monarchy with that, fervent desire for new sovereignty and a strong national identity? It's a powerful symbol of their specific constitutional journey.
Definitely unique. And then, for basic administration, the Constitution names the National Capital District as the seat of government. And it defines the concept of provinces, noting their creation and boundaries will be set by something called an organic law. We'll need to explore that.
Yes, organic laws are important.
Okay, let's explore how laws actually work in Papua New Guinea then. What's the hierarchy? How are they understood? The Constitution lays out a clear order. First, the Constitution itself, supreme law. Then come organic laws, followed by acts of parliament, emergency regulations, provincial laws, and finally, this thing called the underlying law. The key takeaway seems to be that every other written law must comply with the Constitution.
Absolutely. It's supreme.
And acts of parliament specifically have to comply with those organic laws too.
Correct. If there's inconsistency, the lower law is invalid. Simple as that.
So it's a clear pyramid.
A very clear pyramid. And this leads us straight into interpretation, especially of the Constitution itself. What's quite unique here is the Supreme Court's role. It has original jurisdiction over any questions about interpreting or applying constitutional law.
Original jurisdiction, meaning?
Meaning these crucial constitutional questions go directly to the top court first. They're the first and only stop for those initial interpretations.
Keeping it at the highest level.
Exactly. And if any other court bumps into a significant constitutional question, it must refer it up to the Supreme Court. Plus, various authorities, Parliament, the Ombudsman Commission, others can ask the Supreme Court for a binding opinion through special references.
So the Supreme Court is very active in shaping constitutional understanding.
Very active. Proactive, even.
Now, let's get back to that underlying law you mentioned. You said this is where PNG really charts its own course. The Constitution says an act of Parliament will eventually lay out how to develop this underlying law. But until then, what happens?
Until then, the underlying law adopts English common law and equity principles. Specifically, those in effect right before Independence Day.
Okay, so they inherit English law.
Yes, but here's the crucial bit, the real aha moment you mentioned. These English principles only apply if they're not inconsistent with PNG's constitution or statutes.
Right.
Or if they're not, just plain inapplicable or inappropriate to PNG's circumstances.
Ah.
Or if they're inconsistent with custom.
That's a huge qualifier. It gives them massive room to adapt.
Precisely. Massive. If we zoom out, this means the national judicial system, particularly the Supreme and national courts, aren't just passively applying old laws. They have a constitutional duty to actively formulate appropriate rules as part of this underlying law whenever there's a gap.
So they're building law.
They're building an indigenous jurisprudence, as the text calls it. When they do this, they have to consider national goals, basic rights, look at analogies from statutes or custom, maybe laws from similar countries, and critically, PNG's own changing circumstances. It's a mandate to build a legal system that truly fits.
Wow. That's fundamentally different from just applying precedent.
Fundamentally.
So how are these laws enforced? What if someone breaches them, especially the Constitution? The Constitution says individual rights and duties on public authorities are self-executing. What does that mean exactly?
It means they have immediate legal force. They don't need another specific law to activate them. If there's a gap in enforcement, the national court can step in and provide the mechanism to make sure the right or duty is effective.
So they can't just be ignored for lack of enabling legislation.
Correct. And breaching constitutional law carries serious penalties up to 10 years in prison, a hefty fine, K10,000, or compensation. The national court can also issue orders to prevent breaches or fix them after they happen.
Okay, strong enforcement.
And here's another fascinating detail about interpretation. The official records of debates from the pre-independence House of Assembly and the Constituent Assembly, plus the report of the Constitutional Planning Committee.
Historical documents.
Yes. They can be used by the courts as aids to interpretation.
So they can look directly at what the framers intended.
Exactly. It gives the courts a direct line, potentially, to the original thinking behind the words. A powerful guide.
It really shows the courts aren't just umpires calling balls and strikes. They're actively shaping the law, adapting it, aligning it with PNG's unique context and goals.
That's a very good way to put it. Active shaping is key.
So what about those overarching goals for the government? You mentioned national goals earlier. The Constitution introduces these national goals and directive principles. You said they're interesting because they're non-justiciable.
That's right. Generally, you can't sue the government directly just for failing to achieve a national goal.
But they're not just symbolic.
Not at all. Every governmental body has a duty to apply and try to give effect to them. And all laws should be interpreted in a way that aligns with these goals. It guides thinking and policy.
So they have influence, even if not direct court enforcement.
Exactly. And the Ombudsman Commission, for example, explicitly does take these goals fully into account in its work. So they have real teeth through oversight bodies.
Okay, that makes sense. Now, let's talk about the leadership code. You flagged this as a cornerstone for integrity.
It really is, and its scope is incredibly broad. It applies to, well, basically everyone in significant public office. Prime Minister, ministers, MPs, provincial leaders, judges, department heads, police and defense commanders, ambassadors.
Long list.
A very long list. It even includes personal staff of political leaders and executive officers of registered political parties.
Wow. And what does it require of them?
The core duty is clear. Conduct yourself in public and private life and in your associations so you don't have conflicts of interest, demean your office, compromise integrity, or endanger public confidence.
Public and private life, that's strict.
Very strict. It bans using office for personal gain. It requires leaders to ensure their family or associates don't create public doubt. It even demands public disassociation from problematic activities if needed.
And misconduct, what counts?
Misconduct includes being convicted of an office-related offense or simply failing to comply with these very high standards of conduct.
And how is it enforced?
The Ombudsman Commission investigates allegations. Then, independent tribunals chaired by someone qualified to be a judge investigate further. And these tribunals shall recommend dismissal if they find misconduct.
Shall recommend, not may.
Shall. Though they can recommend a lesser penalty if it wasn't serious misconduct, and public policy doesn't demand dismissal. But here's the really powerful part. The appropriate authority, usually the appointing body, shall act in accordance with that recommendation.
So the recommendation is effectively binding. That is a robust system for accountability.
Remarkably robust, yes.
Okay, let's move to the basic rights, guaranteed to all persons in PNG. This section looks quite detailed.
It is very comprehensive.
For example, the right to life. It's there, but with specific legal exceptions listed, like for lawful executions or self-defense.
Yes, clearly defined limits.
Then freedom from inhuman treatment, explicitly banning torture and cruel punishment.
A fundamental protection.
And protection of the law. This covers a lot. Fair hearing, reasonable time, independent court, presumption of innocence.
All the hallmarks of due process, plus things like prompt information on charges in a language the person understands, adequate time for defense, right to an interpreter.
And legal representation, including the public solicitor for legal aid if needed. That's important access to justice.
Crucial. It also covers no double jeopardy, no self-incrimination, generally public trials.
What about liberty of the person? Can people be detained?
Only on specific grounds laid out in the Constitution, things like serving a sentence, court orders, reasonable suspicion of an offense, preventing disease spread, unlawful entry, mental unsoundness, etc.
And if arrested?
You must be told why promptly, allowed contact with family and lawyer, access to a lawyer, and brought before a court quickly.
And bail?
Bail is generally a right, unless justice requires otherwise. The exceptions are very serious crimes, like treason or willful murder.
It seems quite protective of liberty.
It aims to be. There's even a specific right to have the national court inquire to potentially unlawful detention.
What about other freedoms? Freedom of conscience, thought, religion?
Guaranteed, including the right to practice, manifest, and propagate your religion or beliefs, as long as it doesn't interfere with others' freedom. And interestingly, it explicitly includes traditional religious beliefs and customs under the definition of religion.
That's significant recognition of indigenous culture.
It is, and there's freedom of expression and publication, including press and mass media, though reasonable restrictions can be put on public office holders and non-citizens.
Interesting. And there's even a provision allowing laws to ensure reasonable media access and the right to rebut false statements.
Yes, aiming for a degree of media fairness. Then you have freedom of assembly, association, including political parties, unions, freedom of employment, right to privacy, a fairly standard suite of rights, but often with specific PNG nuances.
Okay, those are general rights for all persons. What about rights reserved specifically for PNG citizens?
Good distinction. Only citizens can vote, hold elective public office, and acquire freehold land. That's a major one.
Land ownership restricted to citizens.
For freehold, yes. Citizens also have a right to reasonable access to official documents, though with standard exceptions like national security, cabinet records, trade secrets, privacy.
So a kind of freedom of information principle.
Built in, yes.
Yes.
Citizens also have freedom of movement to travel, reside anywhere, enter and leave PNG unless lawfully deprived of liberty. They generally can't be expelled or deported except through extradition processes.
And property rights for citizens.
Strong protection from unjust deprivation. Property can only be taken for a public purpose or other justifiable reason and requires just compensation, though compensation can be deferred or paid in installments.
Are there exceptions?
Yes. Things like forfeiture for crimes, paying debts, custom ownerless property, environmental protection. But here's a really significant point you noted earlier. These constitutional protections for property explicitly do not apply to non-citizens' property.
That's a major distinction. Non-citizen property rights are governed by separate acts of parliament.
Correct. It gives the state much more flexibility regarding foreign-owned assets.
Finally, equality of citizens. What does that entail?
It states citizens have the same rights, privileges, obligations, duties, irrespective of race, tribe, place of origin, political opinion, color, creed, religion, or sex.
Standard equality clause.
Yes, but with a very important qualifier. Laws can be made for the special benefit, welfare, protection, or advancement of females, children, and young persons, members of underprivileged or less advanced groups, or residents of less advanced areas.
Ah, so equality is balanced with the possibility of affirmative action or targeted support for vulnerable or disadvantaged groups.
Exactly. It acknowledges historical or structural disadvantage and allows for measures to address it. It's equality, but nuanced.
That's a key aha moment indeed, a very pragmatic approach to equality.
It is, which brings us to the critical question. How are all these guaranteed rights and freedoms actually protected and enforced?
Right, having them on paper is one thing.
They are directly protected and enforceable in the Supreme Court or the National Court. These courts can act on their own initiative, or if someone with an interest applies. An interest is defined broadly, includes the law officers, or anyone with an interest in the rule of law itself.
So access to the courts for rights protection is quite open.
Seems intended to be. The courts can make any necessary orders or declarations to enforce the rights. They can even make orders about a statute that hasn't come into force yet.
Proactive again.
And importantly, you don't have to wait for your rights to be actually violated. Relief can be given if there's a reasonable probability of infringement, or even if fear of infringement is stopping someone from exercising their rights.
That's quite forward-looking protection.
It aims to be very practical.
This whole framework, then, shows a really deep commitment to human rights. But it's clearly paired with a pragmatic approach to governance, tackling real-world issues like leadership integrity and national security with very specific, robust provisions.
Absolutely. It's not just abstract ideals, it's trying to build workable systems.
Yeah. Okay, let's turn to the actual machinery of the state, the organs of state. First, the head of state. How does that role work?
Well, Her Majesty the Queen is recognized as the Queen and head of state of Papua New Guinea. This was agreed upon at independence at the request of PNG's Constituent Assembly.
So, a constitutional monarchy.
Yes. But her powers are exercised through a Governor General, who is appointed based on a decision of Parliament.
And how does the Governor General operate? Do they have independent power?
Critically, no. The Constitution is explicit. The Governor General acts only with and in accordance with the advice of the National Executive Council, which is the cabinet, or another body prescribed by law.
Only on advice.
Only on advice. And the question of what advice was given can't be challenged in court. It's non-justiciable. It's purely an executive matter between the GG and the government.
Interesting. What about the term? Can someone be Governor General for life?
No. It's normally a 6-year term, and a person generally can't serve more than once.
Only one term usually.
Unless Parliament specifically approves a second term by a 2/3 absolute majority vote. But a third term is completely prohibited.
So, strict limits.
Yes. The Constitution also details appointment, oaths, resignation, dismissal procedures, which can be initiated by the NEC or Parliament or for medical reasons. There are even provisions to suspend a GG if they fail to act on advice.
What if the office is vacant? Who steps in?
There's a clear succession. First, the Speaker of Parliament, then the Chief Justice, if a citizen, then a minister appointed by the NEC.
A clear line.
This whole framework outlines a strong constitutional monarchy where the monarch's powers are, in practice, largely ceremonial and exercised strictly on advice. It firmly ensures parliamentary sovereignty holds sway.
Got it. Okay, let's look at Parliament itself, the legislative heart. What's its structure?
It's a single-chamber legislature, a unicameral system. Members come from single-member open electorates and single-member provincial electorates.
Open and provincial seats.
Right. Plus, they can have up to 3 nominated members appointed in a special way.
Who can run for Parliament? What are the qualifications?
You need to be 25 years old. You have to be born in the electorate or have resided there for 2 continuous years or 5 years total at any time. And there's a K-1000 nomination fee.
Are there disqualifications?
Yes, standard ones like being under sentence of death or imprisonment for over 9 months, though an appeal can suspend the disqualification temporarily.
And the Speaker and Deputy Speaker.
They're elected by Parliament by secret ballot. They must be members of Parliament. But here's a key check and balance. No minister or parliamentary leader of a registered political party can be Speaker or Deputy Speaker.
Separating executive leadership from presiding over the legislature. Clever.
It aims to ensure impartiality in running parliamentary proceedings.
So what are Parliament's general powers? How does it make laws?
It has that broad power to make laws for the peace, order, and good government of Papua New Guinea and the welfare of the people. This includes laws with extraterritorial effect applying outside PNG.
And can courts challenge laws based on that peace, order, good government phrase?
No. The Constitution explicitly says courts can't challenge a law on that ground. It's a political judgment for Parliament.
Okay. How does a bill become law?
The Speaker certifies it once passed. It generally comes into operation on that date, unless the law itself specifies another date.
Who can introduce bills?
Any member can introduce bills, petitions, ask questions, propose resolutions or motions, though, crucially, bills related to finance generally need to be initiated by the executive, a common feature in parliamentary systems.
Makes sense. What about voting and functioning inside Parliament?
Quorum is 1/3 of the total number of seats, so about 1/3 of MPs need to be present. Voting is usually by simple majority of those present and voting. The Speaker normally doesn't vote, except to break a tie. Unless it's a motion of no confidence or requires a special majority, then they have a deliberative vote.
What about parliamentary privileges, like freedom of speech?
Yes, classic privileges apply. Freedom of speech and debate in Parliament is protected. Members aren't subject to court jurisdiction for their official acts within Parliament. But you mentioned the leadership code.
Exactly. That's the key qualifier. While they have immunity from courts for parliamentary actions, they are still subject to the leadership code for their conduct. So it's not absolute impunity.
Good balance. Any other privileges?
Freedom from civil arrest during parliamentary meetings or while traveling to and from them.
And how are treaties handled? Does Parliament have a say?
Yes, significant oversight. PNG's consent to be bound by a treaty normally requires the treaty to be presented to Parliament for at least 10 sitting days. Parliament can actually disapprove the treaty, preventing PNG from being bound.
So Parliament can veto treaties?
Effectively, yes, before ratification, though they can waive the 10-day period for urgent matters. And importantly, a treaty only becomes part of PNG's domestic law if it's given that status specifically by constitutional law or an act of Parliament. It's not automatic.
Dualist system, then. International law needs domestic incorporation. Correct. This whole process, from lawmaking to treaty approval, really points to a deliberate system of checks, ensuring national interest and strong parliamentary oversight are maintained.
What about internal accountability within Parliament?
Yeah.
At protecting elections?
The Constitution mandates permanent parliamentary committees, like the important Public Accounts Committee. The stated purpose is to ensure full and active participation by backbenchers.
Backbenchers specifically?
Yes. Ministers cannot be members of these committees. The idea is for these committees to have balanced representation from government-supporting and non-supporting parties, and they get full access to ministers and department heads for briefings on major policy, holding the executive to account.
Sounds like a strong committee system. What about elections themselves?
Run by the Electoral Commission, and the Constitution stresses its independence. It's not subject to direction or control by any person or authority.
Crucial for fair elections.
Absolutely. But here's something truly fascinating and quite unique to PNG. There's a specific part of the Constitution focused on protection of elections from outside or hidden influence and strengthening of political parties.
Okay, what does that involve?
An organic law under this section requires political parties to register. They must disclose their assets, income, funding sources, and expenditures to the Ombudsman Commission or another authority.
Transparency in party finance.
Yes. And it explicitly prohibits non-citizens from being party members or contributing to party funds. It also limits contributions generally.
Restricting foreign influence.
Clearly. Candidates also have to disclose assistance they receive and their campaign expenses, and they're prohibited from accepting non-citizen assistance.
Very comprehensive rules.
But here's the real kicker for political stability, and it's quite controversial sometimes. An organic law can actually restrict a member of parliament from resigning or withdrawing from their political party.
Restrict them from changing parties?
Yes, or even from failing to support their party in certain circumstances defined by the organic law. And if a member violates these restrictions, it can be deemed misconduct in office under the leadership code.
Wow. That's a very strong measure against party hopping or political instability.
Extremely strong. It's a truly unique approach aimed squarely at fostering party discipline and government stability, perhaps reflecting challenges faced in the past. It definitely raises interesting questions about individual MP freedom versus party cohesion.
A very deliberate constitutional choice indeed. Okay, let's look at the national executive, the ministry, the cabinet.
Right. The Constitution establishes a parliamentary executive. Meaning ministers must be members of Parliament, and they are collectively answerable to the people, but through Parliament. Standard Westminster model in that sense.
How's the Prime Minister chosen?
Appointed by the head of state, the Governor General, but crucially acting on the advice of the National Executive Council, which itself acts according to a decision made by Parliament.
So Parliament effectively chooses the Prime Minister.
Yes, the leader who commands the confidence of the House.
Now, you mentioned stability mechanisms. What about motions of no confidence?
Yes, this is where PNG's constitution is quite distinctive. The rules are very strict. First, a motion of no confidence cannot be moved during the first 18 months after a prime minister is appointed.
In an 18-month grace period? That's long.
It provides significant initial stability. Second, if a no confidence motion is moved during the first 4 years of Parliament's 5-year term, The motion must nominate the person who would become the next prime minister if the motion succeeds.
Constructive vote of no confidence.
Exactly. It forces the opposition to agree on an alternative leader before attempting to topple the government, preventing a simple vacuum.
Another stability measure. What if it happens near the end of the term?
If a no-confidence motion is passed within the last 12 months before Parliament's term expires, it can lead to a general election instead of just a change of PM.
Interesting options. How can ministers lose their jobs?
They can be dismissed by the head state, but only on the Prime Minister's advice. Or, of course, they can be dismissed if found guilty of misconduct under that powerful leadership code. This whole built-in stability mechanism around no-confidence votes is quite different from many parliamentary democracies. It's clearly designed to prevent the frequent changes of government that can sometimes plague such systems, especially newer ones.
A very intentional design. Okay, moving on to the administration of justice. What does that encompass?
It includes the national judicial system, that's the Supreme Court, the National Court, and any other courts created by law. It also includes the Minister for Justice and the law officers.
Law officers.
Yes, that's the principal legal advisor to the government, the public prosecutor, and the public solicitor.
What are the roles of the main courts?
The Supreme Court is the final court of appeal. It also has inherent power to review judicial acts of the National Court below it. The National Court is the main trial court with unlimited jurisdiction. It also has inherent power to review decisions of lower courts or judicial authorities.
And they have inherent powers.
Yes, both courts have inherent power to make orders, including things like prerogative writs, habeas corpus, mandamus, etc. Basically, whatever orders are necessary to do justice in a case.
What about judicial independence? Is it protected?
Absolutely central. The Constitution states the national judicial system is independent. No outside person or authority can give directions to a court or judge about exercising their judicial powers. The only exception is Parliament acting through legislation that applies generally.
So no political interference in judgments.
That's the principle. The public prosecutor is also independent in performing their functions. There's one very narrow exception. The head of state on NEC advice can give directions if a prosecution might prejudice national security, defense, or international relations. But even then, the direction must be tabled in Parliament.
So highly restricted and transparent. What about the public solicitor?
Their role is primarily providing legal aid, especially for people charged with serious offenses, punishable by over 2 years imprisonment, or when directed by the Supreme or National Court, ensuring access to justice.
And how secure are the positions of judges and these law officers?
Very secure. Judges, the public prosecutor, the public solicitor, and the chief magistrate can only be removed from office for inability to perform their duties, like illness, or for misbehavior or misconduct in office. And crucially, removal can only happen after the allegation has been investigated by an independent tribunal appointed specifically for that purpose.
Strong protections against arbitrary removal.
Essential for independence.
Let's also look at some of the other key oversight bodies mentioned. The Public Services Commission.
Right. Its main role is reviewing personnel matters within the national public service appointments, discipline, etc. It also advises the NEC on organizational matters. Importantly, while it advises, it doesn't have power of direction or control over departments, and in its personnel review function, it's explicitly independent.
Okay. What about the Auditor General?
Another critical independent office. Appointed after reports from the Public Services Commission and the Public Accounts Committee of Parliament. The AG is not subject to control or direction by anyone. Their primary function is to inspect and audit the public accounts of PNG and all government bodies and report directly to Parliament.
The financial watchdog.
Exactly. Essential for accountability.
Then there's the Salaries and Remuneration Commission. This sounds important. Who's on it?
It's comprised of key government figures: the Speaker, the Prime Minister, the Leader of the Opposition, the Chief Justice, key department heads. A high-level body.
And what does it do? Set salaries.
It recommends salaries, allowances, and benefits, including pensions for a wide range of top officials: MPs, provincial assembly members, judges, constitutional office holders, departmental heads.
Recommends. So Parliament decides.
Yes, but here's the crucial check. Parliament can accept or reject the Commission's recommendations, but it cannot amend them.
Ah. So Parliament can't just tweak the recommendations to give themselves a raise. They either accept the independent body's figure or reject it entirely.
Precisely. It's a very strong mechanism designed to prevent politicians from setting their own pay, removing a significant potential conflict of interest.
That is a strong check. This whole system, independent commissions, judicial security, the leadership code, seems incredibly thorough.
It really is. It reflects a deliberate attempt by the framers to build robust ethical governance and create multiple layers of checks and balances against potential abuses of power or corruption. Quite sophisticated.
And how does governance work lower down at the local level?
The Constitution mandates a system of provincial governments and local-level governments. An organic law sets out how they are established, their constitution, their powers, and functions. This includes provisions for elected legislatures, executives, and heads of those executives at the provincial and local levels.
So elected bodies at lower levels, do they have real power and resources?
The organic law is required to ensure they have financial provisions, grants from the national government, some taxation powers that are reasonably adequate for their functions. It also mandates the devolution of substantial decision-making and administrative powers to these levels. The intent is genuine decentralization.
What about conflicts between national and provincial laws?
Generally, the consistency of provincial or local laws with national laws, especially regarding basic rights, is justiciable, meaning courts can rule on it.
Okay.
However, an organic law can declare that certain other types of disputes about the effect of national law on provincial laws are non-justiciable, unless the dispute is directly between the national government and a provincial government.
So some potential disputes are kept out of court, maybe for political resolution.
That seems to be the idea, balancing legal certainty with political flexibility in intergovernmental relations.
Can these lower-level governments be overridden by the national government?
Yes, under specific circumstances. The National Executive Council can suspend a provincial or local level government if it's undermining national unity or if it simply cannot function effectively due to war, emergency, or maybe mismanagement. But this suspension is subject to parliamentary confirmation and reporting. And there must be arrangements to reestablish the suspended government within 9 months. It's not meant to be permanent abolition.
Oversight, but with limits. Is there a body that manages the financial relationship?
Yes, the National Economic and Fiscal Commission, NEFC. It assesses economic and fiscal policies at all levels and makes recommendations on financial arrangements and grant allocations between the national, provincial, and local governments.
Try to ensure fair distribution.
Exactly. Overall, it shows a clear constitutional commitment to decentralized governance, empowering local levels, but within a framework that maintains national unity and provides central oversight and intervention mechanisms when necessary.
Okay, let's shift to Section 5, protecting the nation. What happens during a major crisis like war or a national emergency?
The head of state, acting on the advice of the NEC, can declare that Papua New Guinea is at war, or declare a national emergency due to natural disaster, threatened security, or breakdown of public order.
And then, what powers kick in?
Parliament can then pass special emergency acts, and the head of state, again on NEC device, can make emergency regulations. These laws are specifically for dealing with the emergency and are temporary.
Can these emergency laws override anything, even basic rights?
They can alter most ordinary laws, yes. But, and this is where PNG's constitution makes an incredibly powerful statement, there's a list of fundamental rights and provisions that emergency laws cannot alter.
Non-derogable rights. Which ones?
Section 35, the right to life. Section 36, freedom from inhuman treatment. Section 45, freedom of conscience, thought, and religion. Section 50, the right to vote and stand for public office. Section 55, equality of citizens. And Section 56, other basic rights and privileges of citizens.
So core rights remain untouchable, even in an emergency.
Untouchable. Emergency laws can only alter Section 37, protection of the law, or Section 42, liberty of the person, to the extent necessary to allow for internment.
Internment being detention without trial during the emergency.
Correct. Furthermore, even the emergency regulations made by the executive have tighter restrictions. They cannot alter freedom of expression, assembly, association, privacy, or freedom of information. And they can't impose imprisonment for more than 9 months just through regulation.
Those are vital safeguards against executive overreach during a crisis.
Absolutely. And there's strict parliamentary control built in as well. Parliament must be called within 15 days of an emergency being declared. The Prime Minister has to report on the reasons the emergency laws passed, how they're operating. The initial declaration of emergency only lasts 21 days unless Parliament extends it.
How long can extensions last?
Only up to 2 months at a time, and each extension requires an absolute majority vote in Parliament.
So Parliament keeps a tight leash.
Very tight. Plus, special emergency committees of parliament are appointed. Ministers cannot be members. These committees must be available at all times during the emergency, receive copies of all emergency laws and orders, be consulted where possible, and report back to parliament on whether the emergency should continue, whether the laws are justified, and if any changes are needed. Constant scrutiny.
If we connect this to the bigger picture, that explicit list of non-derogable rights during an emergency is a profound statement, isn't it? It's about the Constitution's deep commitment to fundamental human dignity, even in the most extreme circumstances.
It truly is. It's a powerful safeguard that really stands out compared to some other constitutions.
You mentioned internment detention without trial. How is that regulated during an emergency? It's often a very contentious power.
It is. In PNG, internment is only permitted if authorized by an act of parliament specifically passed for that purpose, requiring an absolute majority vote. And that act only takes effect after a national emergency has already been declared.
So it can't be pre-authorized in normal times.
Correct. And the rights of people who are interned are extensively protected by the Constitution itself. They and their family must get written reasons within 7 days. An intern, unless they are an enemy alien, must be released after 2 months, unless an independent tribunal reviews the case and finds sufficient cause for continued internment.
An independent review is key.
Crucial, and even then, they generally must be released after 6 months total. Internees also have the right to have their case reviewed by the tribunal within 1 month of being detained, and then every 2 months after that.
Regular reviews.
Yes. There's also provision for compensation if the internment turns out to have been wrongful. Their names and where they live must be published. They have to be kept separate from convicted prisoners and treated humanely, and they get access to a lawyer and interpreter.
That seems like a very detailed set of safeguards for such a drastic measure.
It is. There's one more layer. The head of state, on NEC advice, can refuse release even after a tribunal recommends it if national security demands continued detention. But this refusal must be reported to Parliament, and Parliament itself can then order the internee's release.
So ultimate parliamentary oversight even there. It's a very carefully constructed framework for a difficult power.
Very carefully constructed, aiming to balance security needs with individual liberty.
This raises another important question on fundamental prohibitions. How does PNG's constitution explicitly address slavery?
It does so with remarkable clarity and force, though briefly. It states, slavery and the slave trade in all their forms and all similar institutions and practices are strictly prohibited.
A powerful, concise, and absolute ban.
Unequivocal.
Beyond these major sections, what underlying principles guide the state according to the Constitution? Are there general rules of good governance?
Yes, there are some interesting general principles included towards the end. One is about filling of offices. It basically says constitutional offices shouldn't be left unfilled longer than necessary. It also advises against people holding multiple public offices at the same time unless it's clearly desirable because the functions are closely related.
Promoting focus and avoiding concentration of power.
Seems to be the idea. And importantly, it says public offices, especially positions on statutory boards and committees, should try to be filled by people from various different areas of the country.
Promoting regional inclusivity and representation.
Exactly. Another key principle is about consultation. Where the law requires consultation to happen before a decision is made, the Constitution specifies that this consultation must be meaningful and allow for a genuine interchange and consideration of views.
So not just ticking a box, it has to be real consultation.
That's the standard set. These principles, woven into the Constitution, show an incredible foresight, I think, a real commitment to transparency, inclusivity, and genuine good governance right from the foundational document.
Wow, that was a truly incredible deep dive into the very fabric of Papua New Guinea's governance, from that fascinating dual allegiance to the Queen and the people to the intricate balance of inherited common law and that evolving deliberate indigenous jurisprudence, and then that remarkably robust leadership code. It's clear this Constitution isn't just static text, it's dynamic, it's incredibly thoughtful.
It really is. What stands out strongly to me is that deliberate effort to build in safeguards against so many of the common challenges that new nations often face. Things like political instability, corruption, the potential for abuse of power, especially during emergencies.
Yeah.
The sheer specificity of provisions like those non-amendable salary recommendations for politicians or the strict rules around motions of no confidence, they really underscore this commitment to stability and integrity.
Absolutely. And that commitment you highlighted, to actively developing an indigenous jurisprudence while still respecting inherited legal traditions, that feels like a powerful model. For any nation navigating its own post-colonial identity, trying to adapt legal frameworks to fit unique local realities, it's a remarkable balancing act.
It is, and the profound emphasis on parliamentary oversight even, as we saw during emergencies, coupled with those non-derogable human rights, that speaks volumes about the core values they try to enshrine in their system. It's a testament really to balancing national needs with individual liberties in a very detailed, considered way.
So what does this all mean for you listening in? As you reflect on this deep dive, maybe consider how a nation's foundational document can embody both its highest aspirations and its most practical, down-to-earth pragmatism, all at the same time. What lessons about innovative governance, about accountability, and about the deliberate evolution of law can we perhaps take from Papua New Guinea's really compelling example? Something to think about.